Welcome to our second lecture covering gender discrimination. In our first lecture, we discussed gender discrimination, the various moments in the employment cycle in which gender discrimination is more likely to happen or can happen. In this presentation, we're going to discuss disparate impact, which of course is not the major category. This category up here, which I call gender discrimination, you could call it disparate treatment discrimination if you wanted to. We're also going to discuss the topic of gender plus discrimination, and we're going to talk about grooming standards as well. So let's get started. So we're going to discuss that disparate impact. As you may recall, we've talked about disparate treatment and disparate impact. Disparate treatment is when a person engages in intentional discrimination. They are making a choice to prefer one gender over the other gender. They may not be conscious of it, but their actions, that's the motivation behind that. Disparate impact, we're going to be talking about facially neutral policies that, even when they're applied consistently, tend to have a negative impact upon one gender or the other gender. So in this scenario, Mary applies to work to be a firefighter. She's on the short side and she's lightweight. She's denied the position because of her size. If the fire department cannot prove that these requirements are business necessities, then Mary is going to be successful in her claim that she should have been hired. Now, fire departments have generally been successful, saying that you need to be of a certain height and a certain weight to be able to function in, a fire situation, which of course can be chaotic and you may need to climb things or get around things. And if you are on the shorter side, that may be more difficult. You may need to carry out somebody who has passed out or something along those lines. So I'm not saying that the fire department won't be able to prove it. It's just that they need to be able to prove it. We've talked about glass ceilings before, limitations that have stopped the progress of women and minorities in progressing to the highest levels within an organization. A related concept is the idea of glass walls, and you're going to want to add this to your Quizlet. And this is the barriers that prevent women from moving laterally into areas that lead to higher advancement. And of course, I say women here, but it could be minorities or other groups that are having difficulty progressing to the highest levels within the organization. So in other words, if in order to advance to this level from the organization, you may need to do some lateral moves to different positions to be ready for the next move up. That's the idea here. And if there's this barrier that stops you from being able to move to this position, then you'll never have the opportunity to move up here. So that's why these types of barriers are important for organizations to be aware of. And there's a few ways of resolving it. One is to remove the barrier so that the woman or the minority member can advance to these positions. Another approach would be to say, well, maybe you don't really need this step. Maybe you can go from here up to here without going to this step. And maybe you do both. Maybe you remove the barrier and also remove the necessity of this particular jump in the career position. We've talked about Dothard versus Rollinson, so I'm not going to spend a lot of time here. Again, what the employer who has some kind of facially neutral policy but that ends up having a disparate impact is going to have to do is prove that there's a business necessity there. In that case, of course, this was a prison. Was it really necessary from a safety and efficiency standpoint for prison guards to be over a certain weight? And if the prison can prove that it is a business necessity, then Dothard, in this case, the plaintiff, has the opportunity to show, is there a better, less discriminatory way of reaching that same approach? For example, instead of having a weight requirement, perhaps you could have some kind of obstacle course or some kind of weightlifting part of the test that would be able to demonstrate that she had the physical ability to respond to an emergency situation within the prison. So that is, again, when we think about the ping pong contest, she has to prove that it has a disparate impact upon women. The employer then has to show that it's a business necessity. And then Dothard has a final opportunity to show that there might be a better, less discriminatory response. I'm not going to go through Dothard except to note that this whole answer to this question depends on business necessity. If Rawlinson, again, that's a prison official, is able to show that business necessity exists, then it's likely to win, especially if Dothard can't show there's another mechanism for that. Let's talk about gender plus discrimination. We've talked about this briefly before, but this is, again, when we have discrimination that is not based strictly upon gender alone, but some other factor. It could be marital status, or it could be the existence of minor children in the household. So an employer might be able to honestly say, we have lots of women in our organization who are very successful. So how can you say we discriminate based upon gender? But if the women in the organization who are successful don't have children or are not married, and it seems like any woman who is married or has children isn't successful, then we might be looking at a gender plus discrimination case. And even if the plus itself isn't protected, it isn't a protected category, gender plus can still, in combination, create a claim recognizable under Title VII. So Lucy is a teacher at a private non-religious school. It's important, by the way, for the story that it be a non-religious school. Otherwise, we'd have to contend with the ministerial exception. So we're not even going to go down that road with a ministerial exception. So she becomes pregnant before her marriage. She informs the school about her pregnancy, and the principal fires her, saying that it does not want to have an unwed pregnant teacher or an unwed mother because of the damage this would do to the reputation of the school. It might cause enrollment to drop. And under these circumstances, Lucy wants to sue because unwed fathers haven't been discharged under similar circumstances. If that's the case, then Lucy would have a pretty good case of gender plus discrimination against her employer. Again, completely different answer if the school were a religious-based school. So in order to have a disparate impact, or not just disparate impact, but I guess I should say, and gender plus claim to be successful, you are going to need to show that there is that men are either less likely to be affected by it, or don't have, when it's female plus, there's discrimination. When it's male plus, there isn't discrimination, in other words. Phillips versus Martin Marietta is the case in this area. In this case, an employer refused to hire women who had preschool-age children. The idea that Martin Marietta had was probably factually true, which is preschool-age children do get sick often, especially when they're in daycare, which most of the time when both parents work, the children are going to be in daycare at that age. And somebody has to stay home with them because the daycare won't accept them, obviously, if they're sick. And that person is, most of the time, at least, especially during this period of time when this case came down, but even today, is more likely than not to be the mother, the woman. And so Martin Marietta had a policy that they just didn't hire women with preschool age children. Once they got to be school age, presumably their immune system was more robust and there would be less absences. They were willing to hire women without any children. But they were willing to hire men who had preschool age children. Again, the assumption of Martin Marietta was either the man had a wife who was staying at home and would be able to take care of the ill child, or even if the wife worked outside the home, if the child became sick, it would be the wife who would be staying at home versus the husband. Now that's probably, Martin Marietta's take on the world is probably true. That's probably how things usually work out. But that's still an unlawful question to ask only female employees, and it's an unlawful factor to consider unless you're also going to exclude men. Now, an employer who decides that it's not going to hire any man or woman who has preschool age children, I'm going to say that's not a very politically correct or very nice policy to have, but it wouldn't be an unlawful policy to have. Let's consider the topic of gender stereotypes. So this is an assumption about a group, one gender or the other gender, that says either people in this category never act this way, or usually act this way, or always act this way. You know, many stereotypes have a grain of truth about them, but it's unfair to say that because that's true for some, or maybe even most of the people of a gender, that it's going to be true for a particular person. Instead, the employer ought to make an individual evaluation of circumstances. I've listed here some common gender stereotypes that we see. Maybe you've experienced some of these, or maybe you have some of these views yourself. But again, as long that they shouldn't be affecting the employment decisions made. And I'm not going to actually go through these stereotypes. These stereotypes, if they're playing a role in the employment decisions, it would be unlawful. Okay, so we've discussed strict scrutiny when we were discussing race discrimination. We talked about how the Supreme Court has had strict scrutiny for any kind of race-based equal protection challenges. The strict scrutiny is the highest level of scrutiny. And basically it means that race-based distinctions that a government agency does, because they're going to be subject to strict scrutiny, almost are never successful. It's hard to imagine a time where they would be successful. Attorneys joke and say strict scrutiny means it's a loser argument. You know, there's just no race-based claim for strict scrutiny. You know, it's hard to even fashion one or think of what one might look like. Intermediate scrutiny is the middle area. There's also rational basis scrutiny, which we're not going to talk about at this time in the course. But intermediate scrutiny is a less hard level for the government entity to reach. It's possible for the government entity to win under intermediate scrutiny. Not guaranteed, but possible to win. And while this Supreme Court case that I'm about to talk about is not dealing with employment issues, still the concept behind it would be relevant if a woman were working in a government entity, either state or federal. So in this case, Oklahoma had a statute that allowed 18-year-old women to buy beer, but the men had to wait till they were 21. And the Supreme Court said that that was not reasonable, and to have this age distinction here. I'll give you a personal story from my childhood. My parents married in 1960, and my mother at that time was, actually both of my parents were 19, and my mother was able to sign for her marriage license on her own because she was 18 or older. My father, who was actually several months older than my mom, although they were both 19, had to have his mom come down and sign the marriage license on his behalf, because under the laws at that time, males had to be 21 before they were old enough to sign for their own marriage license in the state of Texas. So that's an example. That's no longer the law in Texas, hasn't been for a very long time, but that's an example of that idea. And of course, the logic behind probably this Oklahoma law and probably the Texas marriage law was that women's brains develop sooner than men's brains. The frontal lobe develops a little bit earlier in women than men, and so there is a biological argument to support the idea that women might be able to make somewhat better decisions. I also think, especially with respect to the marriage argument, the idea was that the man would be responsible for supporting the family, and so he needed to not only be ready for marriage, but also be ready for that financial responsibility. In some sense, he was taking on a bigger burden when he married than perhaps the woman was. At least that was what the culture told men and women at that time. Again, I'm just offering this to you as an interesting case that kind of gets at that idea that in some limited senses, we're a little bit more open to gender distinctions than racial distinctions, because as we talked about before, racial distinctions really aren't biological. There isn't a gene that says somebody is of a particular race. Other than the fact that there can be certain diseases that might be somewhat more common in a racial group versus another racial group. But even in that case, it's not as if everybody in a racial group experiences this disease and nobody outside that racial group experiences this disease. So because there isn't really a biological component to race distinctions, it really makes very little sense to have those made by the government. So that's why we have the strict scrutiny. Obviously, with respect to gender differences, these are biologically based. There are differences both in terms of size, in terms of development, and in terms of anatomy that distinguish a man from a woman. And so there is some logic, you know, a man isn't going to give birth. A man isn't going to nurse a child. You know, things along those lines. A woman can't father a child. A woman would lack, you know, some upper body strength that a man might have. So some of the distinctions are anatomical and or biological. So you could imagine there being some arguments that could advance different treatment. And that's why we have the intermediate scrutiny. I'm offering this just to give you kind of a context of the legal area that we're talking about. This particular case is not tremendously tied to employment law. Okay, so there certainly can be employment decisions related to gender stereotyping that can be unlawful. For example, having expectations about how people will act at work. And the key case here is the Pricewaterhouse case, which is a really important gender discrimination case. In Pricewaterhouse, Hopkins was a woman who was quite aggressive. She had was inclined to use salty language, and she had a demeanor that was on the brusque side, on the aggressive side. There were lots of men in her working group that had similar personalities. She wasn't unique in that regard. There were also women in her group that were much more, I'm going to say, quote unquote, ladylike, meaning that they kind of more fully met the cultural expectation of how a woman ought to conduct herself. They weren't swearing. They were more deferential to men. They were less aggressive. They were more, quote unquote, polite. They had a more, quote unquote, feminine aspect to their personality. But of course, me using that word, I'm using it ironically because, of course, to be a female doesn't have anything to do with whether you swear or don't swear, whether you are brusque or very polite. We associate femaleness with those characteristics, perhaps, but that's not accurate. Being a female isn't tied to that. You can be a tomboy and be every bit as much of a female as somebody who's, you know, wearing the frilly dress and the makeup and all the other stuff. So, but anyway, that stereotype was, I guess, in play at Pricewaterhouse. So Hopkins wasn't successful in her job. Her sales were fine, but she wasn't moving up the corporate ladder, again, because of these differences in her style compared to other women. Now, these other women, the ones that were, quote unquote, feminine, unquote, were making progress. So when this case went to trial, Pricewaterhouse said, look, we have lots of women who are very successful in our organization. And it was true that they were successful. But what Hopkins' response is, but if you don't fit that stereotypical model of a woman, then you don't get ahead. If I act like the fellas, the men, then I don't get ahead. The men get ahead when they act like the men. The women get ahead if they act like the stereotypical woman. But a woman who acts more like the male stereotype can't get ahead. And so this is an actionable claim. And this case is important in that, well, it's important in its own stead, because this is kind of like a gender plus idea. Women were successful, so Hopkins can't say the Pricewaterhouse discriminated against all women. But the plus in Hopkins' situation wasn't a child at home or a spouse at home. It was her brusque manner. Now, if Pricewaterhouse had a policy that we don't like people with a brusque manner, whether that person is a male or female, that's perfectly okay for Pricewaterhouse to have that view. Again, employment at will, maybe it's a smart policy, maybe it's not. But that would have been fine to say, no, you're not going to succeed here if you don't have very polite manners, if you swear at work. We don't like that kind of thing. But because they liked it just fine in the men, they couldn't have a separate policy for women. So Pricewaterhouse is important for that idea, but it's also important for the next step. And we will talk more about that when we talk about sexual orientation and gender identity issues. As you can see here, one of the things in play is gender stereotypes in this area could fit into ideas of how gays and lesbians and transgender people are experienced and treated in the workplace. That's kind of the next step. So this was an early action that kind of maybe foretold where we would end up in 2020. So some of the circuits have said that Title VII should be interpreted narrowly, thinking about sex discrimination only as a characteristic of gender, and others have tended to expand it. This view seems to be the one that's holding or is in favor right now, where we're seeing that there is more openness to expand the idea to include things like sexual orientation, and to have a broader notion of what gender might include going forward. And here I have a slide about the Bostock case, which is, of course, a recent U.S. Supreme Court case that ruled that Title VII prohibits sexual orientation and transgender discrimination. So again, the language that the Bostock case depends upon is the word sex. And what does the word sex mean? And again, it's not defined, as I said in our very first slide. This term was not subject to definition in Title VII, nor was there any discussion on the record to what that term might mean. And so the court had to decide, well, does sex, is discrimination because of sex, include sexual orientation and transgender discrimination? And it, of course, concluded that yes, it did. So as a result, now that we have Title VII, which covers all 50 states because it's federal law, we don't have to be concerned nearly as much about what an individual state provides. Prior to this decision in 2020, we would look to state laws because, as we've talked about before, federal discrimination law provides a floor, but it doesn't provide a ceiling in these areas. It provides a minimum level of protection for employees, but individual states, and in some cases cities, can extend more benefits to employees or more protections to employees. And so before Bostock, we saw states having sexual orientation, transgender protections, other types of protections beyond what we see under Title VII. Now, because Title VII has expanded in this area, the state and local laws are much less relevant. Texas's employment discrimination statute still, of course, does not explicitly cover sexual orientation or transgender discrimination. Whether our Texas Supreme Court would look at the word sex in our statute and interpret that to also include sexual orientation or transgender discrimination, we just don't know. That case hasn't come up. My guess is that they more likely than not would not. But at the end of the day, in a way, it doesn't really make a difference because in the state of Texas, we're part of the United States, so Title VII applies in any event. Sometimes people who are LGBT might say, well, especially if they were transgender, they might say, well, my transgender status qualifies as a disability, under the Americans with Disabilities Act. That isn't going to work, though, because the Americans with Disabilities Act expressly excludes homosexuality, sexual orientation, and status as a transgender person from protection under the Americans with Disabilities Act. So again, we'll have a much more extensive discussion of these topics when we get to a later module, but I wanted to at least very briefly describe what the law is in this area, because this is very closely tied to the Pricewaterhouse type analysis. Now let's look at grooming standards. I think this is a surprise to many folks, so I want to spend a little bit of time talking about this. So it is possible for for dress codes and grooming codes to cause legal problems. They can cause problems in religious discrimination cases, and they can also cause problems in gender discrimination cases. They can cause problems in other contexts as well, because employees oftentimes do like to express themselves at work, and you can see these are some pictures that I pulled off some websites, and you can see they're giving advice about how to work. The idea is this is too revealing. You can see some cleavage here. Her arms are bare. Again, you can see a little bit of a midriff here. Again, her arms are bare. Spaghetti straps, a little bit low cut here. The idea is covering up so the person is dressed in a more modest way. But you could see how maybe a person doesn't want to wear that dress or that shirt underneath the dress or the blazer, or maybe maybe doesn't want to wear the longer shorts. And so this can cause morale problems and concerns about individuality and things along those lines. And so it can become problems beyond legal compliance to what kind of workforce do you want to be. And of course, these types of aspects of clothing can cause their own problems. They can be a source of distraction. Is she wearing this type of outfit because she is seeking to spend more of her time flirting than working? Or is there some other motivation there? Who knows? Perhaps there's an inappropriate motivation. Perhaps that's just the way she likes to express herself. And obviously these change over time. Let me tell you a bit of a story. When I started working at my first big law firm in 1990, and throughout till the end of 2000 for sure, women every day wore pantyhose. Women were expected to wear closed-toed shoes. Women were expected to wear skirts or dresses. Men similarly were expected to wear ties, and were expected to at least wear a jacket, a suit jacket that matched their pants to work. They didn't have to walk around their individual offices in their jacket, but they had to wear, obviously, the ties they walked around their office. There were very specific requirements for how you dressed. And the same rules applied to, I don't think that the office men, the men who were the file clerks and things like that, had to necessarily wear a tie. They may have had to, I can't remember. But women who worked as secretaries and office folks needed to essentially meet the same dress code that the women who were attorneys and paralegals had to wear, although I think that it was acceptable for the dresses to be somewhat more casual. So, offices had their own culture. And if I had shown up in 1990 in a dress that showed my bare shoulders, that would have been the end of the world. It would have been like the zombie apocalypse in the office. I don't know how people would have been able to handle it. If I had worn shorts, oh my gosh, even on a Saturday or Sunday to the office, would have been just, the world is coming to an end. So you have to think about the particular environment that you're in. Fast forward to 2020, many of these outfits don't, even the ones that are the befores, don't seem nearly as shocking to our sensibilities as they would have looked in 1990. So these values, these cultural norms are definitely a moving target. And you have lots of levels of cultural norms when we talk about this. You have just the overall culture, and then you have a particular industry's culture. And generally the legal industry is considerably more conservative and formal than other industries. And then you have the specific culture of your employer. Again, my first employer, when I graduated from law school, was a very traditional law firm that prided itself on being not necessarily politically conservative, but of being conservative in what they would have seen as the best sense of that word. Maybe we'd agree, maybe we wouldn't agree, but so that would have been, in 1990, that experience, that law firm would have been one of the more conservative places of working in, and that was in Houston at that particular time. But even anywhere in 1990, you wouldn't have seen people going to work in an outfit like this, or an outfit like this, or an outfit like this, unless they were not going to work in a white collar office environment. So values change over time, and employers should change to reflect those as well. So dress codes can cause a lot of morale issues and a lot of concerns along those lines. Let me pause and do a little bit more discussion about some of those things I was talking about. A common topic in female attorney discussions is it okay for women to wear slacks to court? And is it okay to not wear pantyhose to court? Both of those are things that no one would have even thought about in 1990. Of course, a woman has to wear a dress with a jacket, or a suit with a skirt to court. That would have just been self-evident to people back in 1990. And of course, a woman would have to wear pantyhose. In 2020, many women elect to wear slacks, and even if they wear a skirt, they may not wear pantyhose. So that is a change in time. Obviously, you'll want to, as you go to work in law firms, see how women who are attorneys are dressing. And my suggestion is to dress as they do. If you see that they are wearing slacks, then it's okay for you to wear slacks. If you see that they are not wearing slacks, then my advice to you would be not to wear slacks. I would follow their lead. And when it's time to go to court, I would, go with the expectation that I'm going to be wearing a suit with a skirt, and I would probably ask somebody whether the pantyhose is something that is necessary or not necessary. Better to ask those questions and be told it's not necessary than to assume it's not necessary and be running to find some pantyhose really quickly. So those are some things to keep in mind to make sure that you are in tune. It's probably not a good idea to be the trailblazer in these areas. You are going to cause yourself to make some maybe enemies is too strong a word, but you don't want to be the person who's pushing at the boundaries in this particular area. Be the person who fits in, be the person who fits the expectations of the group. And if anything goes a bit above, if the standard is here, this is how most of the paralegals dress, female paralegals, and this is how the female attorneys dress, strive for being up here. Similarly, if you are a male paralegal, dress the way the male attorneys dress. That is a smart strategy to be taken more as a professional. That can mean that you get more opportunities and that you are held in a higher esteem. And much of this is unconscious. The people making these judgments about you aren't even aware they're making them, but they really are things that will affect your career trajectory in subtle and sometimes not so subtle ways. So generally speaking, though, from a legal perspective, dress codes are not something that really raises much in the way of legal issues. Now, if there is truly an unlawful dress code issue, what the employer can't do is say, well, gosh, we told the employee he knew when he was signing up, or she knew when she was signing up, so she shouldn't have come to work here, or he shouldn't have come to work here. That's not a defense to an unlawful practice, really, in any area. Title VII does not permit rate restrictions for a particular category, for either men or women. So if a woman can't be over X number of pounds, then there needs to be a weight restriction for men. It doesn't have to be the same weight restriction, because obviously, typically men are larger, and so they're going to weigh more. But if the weight restriction for women is 130 pounds and the weight restriction for men is 250 pounds, well, obviously there's a disconnect there. It should be at a proportionate level. And so we ought to see the same levels. Now, obviously, this is going to go from a job duty to job duty. And so, an employer might have a weight restriction, say, on flight attendants because of safety issues, because of the narrow pathways the flight attendants need to travel through. And so if there's a weight restriction for women, there should be a weight restriction for men. But there may not need to be a weight restriction for pilots and flight engineers. And so if there isn't one for the male pilots, there shouldn't be one for the female pilots. So while there is not a problem with having grooming standards and clothing standards, they should be consistent in terms of the same level. So if women have to wear certain types of clothing, men shouldn't be allowed to wear whatever they want. And if women need to wear a uniform, then men should also need to be wearing a uniform. If the feel of the man's outfit is professional person, and the feel of the woman's outfit is clerk or something at a lower level than a professional person, then that's problematic. But it's fine to have a policy that says men need to wear khaki slacks and women need to wear khaki skirts. That's not legally problematic. Is that a good policy in terms of keeping your employees happy? That's something that is probably worth some discussion within the organization, but it's not going to raise a legal problem, at least not in the vast majority of states, and certainly not in Texas. Let's consider these scenarios. Male employees cannot successfully sue for gender discrimination based upon not being allowed to wear long hair, even if there's no such limitation on female employees. Bob owns a line of cosmetics, and he hires makeup artists, and they're all required to wear black at work, both the males and the females. The males wear black pants and black t-shirts. The females must wear black skirts and black tops. So this seems balanced, same thing here. But, so she's wearing skirts. She wants to wear slacks like the men wear. But most likely she's not going to be successful because, again, it's just as easy to wear a skirt as it is to wear pants. And so she's probably not going to be successful in her gender discrimination claim. The courts do give employers discretion because the idea is, I mean, look, what's the big deal? It's clothing. You know, it's kind of like there are lots of aspects to employment relationships that people don't like. You know, there's almost every aspect of a job is going to have something positive and negative. And this is a relatively minor aspect. And assuming it's balanced, you can kind of go with it, so to speak. Now, if one of the genders, though, is asked to spend significantly more money to maintain that grooming or clothing expectation, or the preparation they have to undergo is significantly more time-consuming, that's when you can actually successfully win. You know, it's just as quick to put on a skirt as slacks. It's just as inexpensive to buy a skirt as slacks. So that's why Mary's argument isn't good. But let's say the pants that the men are required to buy are $20, and the skirts the women are required to buy are $120. Well, now that does look like gender discrimination. Or let's say that the skirts are very involved. There's multi-tiers and, you know, they have to be fluffed and ironed a certain way. So they, I don't know why you'd want this, but let's imagine that. And so before you put on the skirt, it takes 30 minutes to kind of arrange all the pleats and do all this, the pressing and things like that. Whereas the pants are just, you know, permanent press, throw them, pull them out of the dryer and put them on and you're ready to go. Well, then in that situation, Mary might be more likely to be, or she would have more luck advancing her claim under those circumstances. Let's consider the dress code for Scorpion Cosmetics. The workers are required to wear a uniform, but the female employees are also required to wear makeup. The men are only required to keep their hair neatly trimmed and their nails neatly trimmed. If the only requirement is that the women wear makeup, the only additional requirement, then that's probably not going to be problematic. You know, makeup can be applied in 2 or 3 minutes. Maybe that's not the most artistic approach, but if it's if that's the limit of the requirement, then women are not being significantly adversely burdened with having to apply makeup under those circumstances. Let's consider the Kelly case. Now, the first thing to keep in mind is that this is a public employee case. So even though the public employee isn't successful, at least the public employee had a chance at a constitutional argument. If Kelly who is the plaintiff in this case, if he had been employed not as a police officer, but say as a private company security guard, this wouldn't have even, you know, been worth anybody's time to consider. Everyone would have agreed, of course, Kelly doesn't have any constitutional rights in this situation. But even as a public employee, Kelly did not have any rights, constitutional rights in this situation. So Kelly was a police officer, and he challenged the rules at this time that this particular police force did not allow police officers to have facial hair. And in fact, they even regulated the sideburns. Well, Kelly wanted to have facial hair. I believe he wanted to have a mustache. And the police department said, no, you can't. So he sued, saying, hey, this is my body. This is my personal freedom. I should be allowed to have this and maintain my job as a police officer. After all, I can do just as good a job policing my beat with a mustache on as if I didn't have a mustache on. The U.S. Supreme Court sided with the police department and said, no, police department knows what they're doing. They know what needs to be done to maintain the safety of the public and also to develop an esprit de corps within the ranks of the police department. You know, there needs to be that camaraderie. And having similar dress codes and grooming codes can assist that. Plus, we want to make sure that police officers have the respect in the community, and perhaps having facial hair might cause the general public to have less respect for that individual officer, which could mean that the ability of that officer to police effectively could be diminished. So for those reasons, Kelly was not successful. You don't need to know the name of this case. I'm just giving this as another example about how the courts give a lot of latitude to the employer when we're talking about grooming standards. This is the makeup case. Does the requirement that women wear makeup constitute disparate treatment sexual harassment? It does not. In this case, Jesperson was a bartender. She worked there for a lot of years. She didn't like to wear makeup. And initially she wasn't required to, but over time, the casino became more and more requiring in terms of the physical appearance of its female employees. Women eventually needed to wear stockings and colored nail polish, and they had to style their hair a certain way. And eventually women had to wear makeup. Jesperson refused to wear makeup. She was fired. And she sued over that. Obviously, the men did not have to wear makeup. And the court was examining the unequal burdens argument. That Jesperson was saying, hey, it takes time, it takes money. You have to buy the makeup and then you have to apply it. The fellas aren't having to do that, so this is gender discrimination. But the court said, no, Jesperson did not produce enough evidence to show that there was this true unequal burden. If she had been able to, she would have won. So if she had been able to prove, for example, it took 30 minutes a day to apply the makeup, or it cost, $100 a month to buy the supplies necessary, she might have been successful. But that's not what she was able to demonstrate. So she's going to have to prove unequal burdens. Now this case is from the Ninth Circuit. Let's see what year it is. Reasonably recent case in the Ninth Circuit. And if the Ninth Circuit, our most liberal circuit, is fine with requiring women to wear makeup, you can see how there's not much flexibility on this issue in terms of the law. Now, I'm not suggesting that your clients adopt this policy because, again, it can have implications beyond the legal compliance to employee morale and things along those lines. But it's not really going to raise legal issues. So we are now completed with our second lecture, and we've talked in this lecture about disparate impact, gender plus discrimination. We've talked about gender stereotypes and grooming standards. In our next lecture, we'll talk about customer preferences, equal pay and comparable worth, gender as a BFOQ, and pregnancy discrimination. I thank you for your attention. I hope this information has been helpful for you. If you have any questions, please feel free to stop by. I would be delighted to talk with you in more detail about these topics. Thanks again.